Now, the South African Human Rights Commission says the outbreak of the COVID-19 pandemic has led to a new category of violations being reported. In its annual trends analysis report for the 2020-2021 financial year, it appears that most of the enquiries were related to mandatory vaccination in the workplace. Let's get more on this now, and we speak to the Commissioner of the Human Rights Commission, Advocate Andre Guam, who talks to us from Cape Town. Advocate, thank you very much for your time. Just take us through the various categories within which complaints were submitted to your organization. What stands out?
Yes, what stands out is three categories of rights violations: equality, just administrative action, and socio-economic rights. These have consistently remained in the top three rights violations reported to the Commission, and equality has remained the right with the highest number of complaints made to the Commission after over the past 9 financial years, including matters relating to unfair discrimination on various grounds, as well as matters concerning hate speech.
Yeah.
But obviously, there are also the socio-economic rights, including health, education, the right to housing, and so on.
Let's tackle the mandatory vaccinations. Those, I suspect, you would have been quite inundated with people complaining that their jobs are at stake. Just how much or how many complaints have you received in this regard, and how do you go about resolving it? Because some people may already be sitting at home without jobs.
Yes, of course, that's been a new category of rights violations that have been reported to us in the form of complaints. Each and every one of these matters had to be determined based on the circumstances of the specific case. In certain instances, we have provided advice to employees, and some of these matters could be resolved amicably. In other instances where we received specific complaints, we made use of alternative dispute resolution in many instances. And in many instances, we could reach agreement with the employers pertaining to the issues at hand. It is obviously a matter of assessing the risk for employers and then coming up with a policy. And in each and every case, we need to determine whether the limitation of rights that is taking place in these instances, whether it satisfies the provisions of the limitations clause, section 36 of our Constitution, which determines that rights can indeed be limited, but it needs to be a justifiable limitation, essentially applying a proportionality test in terms of the limitation provision.
Let me refine my question, Commissioner. What advice do you give to a person who's already lost his or her job? They're sitting at home and they're wondering what to do. What is their legal recourse?
Yes, of course, these people could once again, approach the CCMA or the Commission for us to provide assistance and to see what we can do, but it will depend on the circumstances at the time. At present, we're seeing many institutions and corporates, including a bank like Standard Bank, for example, that do not apply mandates anymore, according to the information we're receiving. So it would depend on each and every instance and case and the circumstances at the time, because as we know, things have changed a lot over time pertaining to COVID and pertaining to the restrictions applied. And in each and every case at the particular moment in time, we'll have to determine whether the limitation has been justifiable or not.
Very briefly for me, in the school environment, what kinds of complaints have you received in that regard?
Yes, well, we've received various complaints dealing with the right to a basic education, which is immediately realizable related to LTSM, learner-teacher support material in some instances. It related to the pit latrine matter. We're still looking into that case and would most probably revert to litigation quite soon, as we are in the process of appointing attorneys as far as that is concerned. It relates sometimes to learners that have difficulty in getting access to educational institutions, where it is claimed that institutions are full, or where departments of education need to be engaged by us to make sure that learners get accommodated. It also relates to matters concerning undocumented learners, for example. Despite the Pakamisa case, in which we have been involved in the Grahamstown High Court, we still find undocumented learners sometimes being discriminated against, in the sense that they're not allowed access to schools and so on. So yes, it does relate to matters involving infrastructure and many different issues impacting directly on the right to a basic education of learners.
Advocate Andre Guam, thank you very much for your time.